You're watching Wisconsin Eye, an independent, nonprofit public affairs network, engaging the citizens of Wisconsin since 2007 through access to government proceedings and public policy events.
So this is the enforcement journey, kind of navigating Wisconsin's options for enforcing victims' rights.
Welcome, everybody. My name is Morgan Young, and I am going to be navigating us through today's session. So just as an overview of what we're going to talk about today, we will introduce our panelists today. We are incredibly lucky to have real subject matter experts from a number of areas that are going to talk about their unique role and the unique role of their offices in a survivor's journey through the court system. We are also going to have a case study that we are going to walk through. It is totally fictional, but involves a lot of elements that we do see survivors deal with when they are in the court system. We are going to hear from the panelists as to what they might recommend at specific points. And then we are going to have the question and answer period at the end. So just for everyone's reference point, we have the Q&A open. Some people are used to using a chat. We're going to use the question and answer sessions today. So please feel free to put your question into the question and answer box as we go. We might not be able to answer the questions real time, but we do have some time reserved at the end if we don't get to your questions just in the course of what we're covering. So stay tuned and we'll get to those later. For today's panelists, again, my name is Morgan Young. I'm with the Office of Judicial Education in the State Courts Office, but we also have Ann Kesnick in OCVS, Julie Brown from the Crime Victim Rights Board, Jeremiah Van Hecke from the Wisconsin Judicial Commission, Megan Lee from Wisconsin Judicare, and they're all going to take a moment to introduce themselves further and explain a little bit about the work they do. Ann is up first.
Hi, everybody. Thanks for joining our session. My name is Ann Kesnick. I am a victim rights specialist in the Wisconsin Department of Justice Office of Crime Victim Services. I'm delighted that you have chosen our session to spend the morning with us. As Michelle said in the introductions, this session really is a two-part session, and we encourage you that if you're here for the first part, to please stay with us for the rest of the morning. As I said, I'm a victim rights specialist, so I assist crime victims and witnesses that contact the Department of Justice with complaints or concerns about either victim rights or witness rights. Our office assists both victims and witnesses statewide. Beyond providing the informal victim rights complaint process, we do also do what we call general assistance with folks that contact our office, which includes providing referrals to resources, general information about the criminal justice system, information about victim and witness rights, and then again, if a victim or a witness has complaints or concerns about their rights, we do the informal victim rights complaint process, which we will talk about a little bit later. For a point of reference about how folks get to our office, they typically call. We have a toll-free line that is staffed Monday through Friday, 7:45 a.m. to 4:30 p.m. It's not a crisis line, but folks reach us by calling and speaking with one of our victim services specialists who triages the calls and determines where the caller should be routed to. Folks are also accessing our services by email. So you are welcome to write down this phone number, the email address, and the mailing address, so that if you are referring victims to our office, this is how they can get a hold of us. Thanks for being here with us this morning, and I will turn it over to the next presenter. I think it's Julie. I'm not sure if she's been able to join yet.
I don't see Julie, so maybe we'll just skip ahead and we will hear from Jeremiah next.
Thanks, Morgan. Good morning, everybody. My name is Jeremiah Van Hecke. I'm the Executive Director of the Wisconsin Judicial Commission. I've been in this office since 2013. The commission is, unique in terms of the agencies and entities that have been invited to speak today, because we do help all members of the public, including victims. So our complaints aren't limited to victims. We do take complaints from any citizen, criminal defendants, attorneys, plaintiffs, defendants. But we do handle case involving victims, and we do that by reviewing complaints for alleged violations of the Code of Judicial Conduct. So there's complaints against judicial officials. The commission is responsible for investigating and prosecuting the claims meeting the requirements of the code. We're also subject to an administrative code and our statutory mandate. So we investigate and prosecute those claims. And if the circumstances weren't under the statute, we prosecute those before the Supreme Court. Now, just a few preliminary notes about the limits of the commission and what it can do. We cannot intervene in court proceedings, so we can't come down and pull a judge from handling a case. Usually we're involved after the fact when it comes to this stuff. And these are only complaints involving the Code of Judicial Conduct, which is contained in Supreme Court Rule 60. We're not an appellate court. So it's, we don't handle matters like, say, the length or lack thereof of the sentencing that a judge has the discretion to impose. But we do handle some types of complaints that involve the judge's treatments of victims and witnesses that we'll talk about in a little bit more detail in a little while. You can reach us via a phone, U.S. mail, email. We have a facsimile number, or fax number, if anybody wants to send us a fax. If anybody still does that, we have it. So you can go ahead and use that if you'd like. That information is on our website, and I would highly suggest that if you do have any questions about our operation to check and the types of complaint we receive, our methodology, check the website first. There is a brochure on the app for this conference, so that's a good place to start as well. And I look forward to chatting with you all today a little bit about these hypotheticals and the work that all of us do. So thanks for inviting me here today.
Thank you, Jeremiah. Megan, how about you?
Good morning, everyone. I'm Megan Lee. I'm an attorney with Wisconsin Judicare. More broadly, Judicare represents individuals in Wisconsin's northern 33 counties and Native Americans statewide. But specifically, our Victims' Rights Project is a statewide project. So Judicare covers the northern half of the state and Legal Action covers the southern half of the state, representing victims of crime, dealing with privacy issues or any issues related to their rights as a crime victim. We help through providing advice, connecting victims with different referrals, including direct representation of victims within the criminal case. In order to get assistance, victims can apply online, but we also do work a lot with district attorneys' offices and other agencies to get direct referrals with a victim's informed consent in order to provide them with representation or advice or, really whatever fits their legal needs in each situation. I don't see Julie yet, so we can give her a chance to circle back later and maybe transition over to the case study.
Yeah, we will hear from Julie later. So as we begin our case study, I just have to give a standard disclaimer. We're going to use gender neutral terms as much as possible. We seek to be inclusive. We don't want to fall into the stereotypes of male offenders and female victims. Also, as I mentioned earlier, this case study is a fictional illustration of the rights violations a victim could face. So any similarities to actual cases are unintentional. These are just commonalities we see in the work that we do. I am going to read us the scenario as we go. You will get summaries on the screen to follow along. And then we'll stop occasionally and hear from our panelists to see what they would do or what kind of insights they have for these points in the process. So let's begin. For background, Jesse and Casey had been on a few dates but had not been intimate. On their fourth date, Casey sexually assaulted Jesse while threatening Jesse with a knife and at points strangling Jesse. Jesse went to the hospital because they were having difficulty breathing. While at the hospital, Jesse disclosed the assault and had a SANE exam, and that was completed. Jesse reported the assault to law enforcement while at the hospital. Law enforcement in turn referred the case to the district attorney's office for charges. Jesse was told by law enforcement that they would be contacted by the district attorney's office once the charging decision was made. Law enforcement did not provide any additional information about rights or resources for Jesse. A few months later, Jesse received the victim's rights packet from the district attorney's office. Jesse felt overwhelmed, lots of paperwork, didn't return any of the forms. However, Jesse did call the victim witness coordinator, Aaron, to ask to receive notice of the hearings and to be involved in the case and learn about the case progressing. Jesse also asked to meet with the ADA assigned to the case, and this was ADA Doe. The victim witness coordinator notified Jesse of the initial appearance, and Jesse attended the hearing. After the initial appearance, Jesse met with ADA Doe and Aaron from victim witness to talk about the case. During this meeting, Jesse told ADA Doe and Aaron that they wanted to be kept in the loop about what was happening in the case. They wanted to go to all the hearings so Casey would know that they would not be intimidated. Initially, the DA charged Casey with first-degree sexual assault and strangulation, suffocation. A few weeks later, Jesse reached out to Aaron to let them know that some weird things had been happening. Jesse told Aaron that they had received a package of dead flowers and a dead rat signed C. Jesse also saw Casey's vehicle drive by Jesse's work and house numerous times, even though Casey lived and worked about an hour away from where Jesse lived and worked. Aaron told Jesse to report these incidents to law enforcement so the DA's office could do something about it. Jesse dutifully filed reports with law enforcement, and ADA Doe filed additional charges against Casey. After the stalking report was referred to the DA's office, ADA Doe additionally charged Casey with bail jumping and stalking. Throughout the case, Jesse had been meeting with ADA Doe and Aaron after every hearing to talk about the case. ADA Doe talked with Jesse at one of these meetings about a possible plea. Jesse told ADA Doe that they wanted Casey to be in prison for at least some period of time and did not feel comfortable with any offer that did not include prison time and a lifetime sex offender registration. ADA Doe presented an offer including prison time and sex offender registration to Casey, but Casey refused and wanted to take the case to trial. ADA Doe told Jesse that it seemed like a plea was off the table and that they would be preparing for trial. Jesse told ADA Doe that they would rather go to trial than have Casey take a plea with no prison time. Leading up to the scheduled trial dates, Jesse met with ADA Doe and Aaron several times to prepare for the trial. During these meetings, ADA Doe did not mention any possible plea deals. Jesse had been in counseling since the assault and been providing their bills to Aaron for future restitution claims. Before the final pretrial, Jesse met Aaron in the victim witness office to walk through the courtroom together. Aaron and Jesse talked about the impending trial. At that final pretrial, ADA Doe told the court that the parties had reached a plea agreement and asked to move forward with plea and sentencing at this hearing. Jesse was shocked and had no idea what was happening. Judge Dreykov agreed to move forward with a plea and sentencing instead of the final pretrial. So at this point, I'll open this to the panelists. Can you spot any possible violations of Jesse's rights?
I would say, as a starting point, just that basic foundational right at the start of both the Constitution and the statutory rights of, dignity, respect, courtesy, sensitivity, and fairness, just by not giving Jesse any heads up about what was going on. That's for me, a big kind of foundational right that was potentially violated here.
So do you see any opportunity at this stage for Jesse to access more information about these rights and enforcement options?
Now, I'm not a prosecutor, but if I were in the DA's position, I would definitely recommend either a brief recess or asking for sentencing to be set separately, just to allow Jesse time to enforce their right to, be heard, to talk, give their victim impact statement and be prepared for sentencing, at least from my perspective.
Does anyone else have anything at this point that they want to share? I see Anne.
Sure. So right in the beginning, I'd like to highlight the fact that law enforcement did not provide Jesse with any victim's rights information. And I know in this scenario, the case was charged, but I really want to highlight the importance of that right and give the example that had this case not been charged, Jesse would not have known about very valuable resources such as crime victim compensation, because they would not have been given that information from law enforcement. So it's important that law enforcement remembers that this is considered a gateway right for victims to understand they have rights, what those rights are, and how to access those rights. And beyond that, in this scenario, Jesse talks about threats and intimidation from Casey. On that victim rights form, there should be information for victims to access about what to do if they experience threats or harm from the person that's accused of that crime. So again, the importance of written information from law enforcement. And even though this case was charged and Casey would have received that initial packet from the district attorney's office, that doesn't undo the fact that law enforcement has that responsibility to provide that written victims' rights information. So Jesse, may contact DOJ to pursue a complaint that law enforcement did not provide that victims' rights information. And I'll talk about later what I would do with that sort of complaint if it were to come to DOJ. Another complaint I think that could come out of this fact pattern is the right to confer. I understand that Jesse was consulted with by the prosecutor and victim witness several times, but in my opinion, I think the ball was really dropped when the prosecutor continued to engage in plea negotiations with the defense attorney and did not inform Jesse of that plea offer that was finalized, and did not inform Jesse of the change in the type of hearing regarding the final pretrial. So I also think there could be a conferring complaint as well as a notice of proceedings complaint.
So those are really great points. And you hit on kind of the next question I was going to ask. We have 103 people watching us from various backgrounds. So you mentioned a referral to your office, and you'll talk more about what that would look like. Are there any other referrals that would be appropriate for Jesse at this point?
Yeah, so a little bit of background about me is I did work in victim witness in a district attorney's office before coming to DOJ. So I know what it's like to be in victim witnesses' shoes, and I can understand the uncomfortableness of referring a victim to DOJ to complain about something that your office may have done or didn't do. And I'll hit on this a little bit later, but it's important to remember that the right to complain to the Department of Justice and the right to seek review of a complaint by the Crime Victims' Rights Board is not a courtesy. That's a right that a victim has. So I think referring Jesse to DOJ to potentially pursue a victim's rights complaint would be an appropriate referral. Also, if I was victim witness or if I was an advocate working with Jesse and I was hearing these things, I may consider referring Jesse to legal action or Judicare if Jesse is expressing concern that they're having issues with asserting their rights. And beyond that, they may say, I'm not interested in an attorney and I'm not interested in filing a complaint with DOJ, but I want to assert my rights in court. And at that point, I may refer Jesse to, there's a court form. It's the CR 296. It's available online on the court's website, and it's a request for enforcement of victims' rights. So if Jesse wanted to attempt to assert their rights in court on their own, that may be a referral that I would make in a resource that I would point Jesse to.
Great. And for everyone frantically writing that down, I put it in the chat so everyone can see CR 296 is the form that you're referencing if people want to pull that. Megan, do you want to say anything about how a referral might look if it came to your office at this point, or do you want to save that for later?
I can talk about that briefly. That can really come from anybody. That can be from Jesse applying on their own, or from victim witness just reaching out, or an advocate reaching out on Jesse's behalf to make the referral to our office about possible either advice or representation. And I think Anne hit on a lot of the points that I wanted to also mention, that the biggest thing for an attorney too would be to advocate for the hearing to be held over in order to really allow Jesse the opportunity to exercise their rights, to be heard. Clearly they should have received notice that this hearing was going to be a clean sentencing instead of a final pretrial. But that victim impact statement is an incredibly important tool. So if Jesse didn't have that prepared already, giving them time to prepare that would be incredibly important at this point.
Any other thoughts before we move on and see how this case progresses?
Just to pipe in for purposes of completeness, there's nothing at this point, because we're limited in terms of what the commission does to what the judge has done. And at least at this point in the hypothetical we're discussing, there isn't anything that's jumping out at me in terms of potential violation of the Code of Judicial Conduct. But I just wanted to put my 2 cents in for the sake of completeness, and I'll be talking a little bit more after the next slide or two.
Great. Thank you.
This is Julie.
Can I add something? Oh, go ahead, Julie. Sorry.
Hi, thank you. And I apologize. My camera's going to be off. We've got technical difficulties, so I'm here, and we'll keep it the way it is and not risk any other problems. As Ann mentioned, the court form, I think that's a great referral at this point. And then there is a very little used authority that the board has called equitable relief. It still would require that somebody go through the Victim Resource Center first. So it would be something that Ann's position might work with in conjunction with the board. But that is something that has in the past been used when time is of the essence in order to prevent a right from being violated. So that's one more thing, although not very often, could be a possible referral at this stage.
Great. Thank you. Ann?
Yeah, I just wanted to add one thing for the prosecutors out there. I really encourage you that if you find yourself in the situation, that you remember that you can assert a victim's right on their behalf as well. That if you're hearing from a victim that they want more time to prepare a victim impact statement, if the victim wants more time to confer with you. I know one of the questions that somebody posted in the session is, how do we avoid a violation? I think this is a great example of that. Asking the court for an adjournment to allow you as a prosecutor to comply with victims' rights as far as notice and the right to confer would be a great idea. I always say the defendants ask for continuance because the weather's not great or they change their mind about something. That as a prosecutor, you should feel empowered to assert and assist a victim in exercising their rights. And that may be being the voice for them to the court and asking for an adjournment. Maybe it's just a couple of days. Maybe it's, we'll come back in the afternoon, that Jesse just really wants a chance to meet with ADA Doe to discuss the offer and work on a victim impact statement. As a prosecutor, you're in a unique position because you're representing the state, you're a party to the case. You have the ability to assert the victim's right on their behalf, and you should feel empowered to do that. And listen to your victim witness coordinator. As a former victim witness coordinator, if you're hearing from them that a victim is saying they need more time, they want to confer with you, please take that and listen to that and relay that to the court.
Great. So I think that's all really helpful, but we know that things don't always work really perfectly. So moving forward in this case, we do have the plea agreement and the joint sentencing, and the agreement and recommendation is to reduce the felonies to 2 misdemeanors and no jail time and no sex offender registration. So obviously, Jesse is not okay with this. Jesse was dumbfounded by this recommendation, but asked the judge if they could have more time to get an attorney. One of the things we recommended. Judge Dracov told Jesse that they did not have the right to an attorney, and it would be a waste of the court's and the party's time to delay any further. Judge Dracov denied Jesse's request and proceeded with the plea and sentencing. ADA Doe made statements related to the plea agreement and sentencing recommendations. Judge Dracov asked if Jesse wanted to say anything. Jesse said that they had not written their victim impact statement yet, and they had planned to do so after the trial if Casey was convicted. Jesse again asked for more time, at least an hour. just to put together a victim impact statement, given how uncomfortable Jesse was talking about the effects of the assault in public. The judge told Jesse that they did not understand why Jesse couldn't just speak up at the hearing because Jesse was already there, and again denied Jesse's request. Casey's defense attorney made statements related to the plea agreement and sentencing recommendations. Judge Drakov asked if Casey wished to speak, and they did. Casey read a prepared statement for the judge and apologized that Jesse misinterpreted what happened. Judge Drakov accepted the plea agreement and the sentencing recommendations. So, we've talked about some of this already, but can anyone spot possible violations of Jesse's rights at this point?
I think, again, to echo kind of what was said before, definitely having noticed that this was coming, but really that right to be heard, that right to have the judge consider the economic, the physical, and the psychological impacts of the crime on the victim, especially when, entering the sentencing, making sentencing orders. Having that would be an incredibly important piece for Jesse to be able to really exercise those rights. I think it's something that, Anne said too about the prosecutor really being empowered to step up and say something. It is not an ideal situation to have the victim be silenced in this situation, especially when, realistically, the victim has very little control over the criminal process. So their one opportunity or, their one pathway really to have an input or have an impact on the case is through that right to be heard, is through that victim impact statement. So to deny them that is really, really disappointing in this stage. And, from a victim's rights attorney perspective, I have had cases before where potentially the plea is far different from what was initially charged or pretty inconsistent. And that has been sort of questionable. So something that I've done in the past, it has been rare. So it's not something that we're doing all the time, but is just really making a formal request for the judge to deny the plea agreement, just on the grounds that it is not consistent with the charges or with the situation. That is potentially an option. It's not necessarily successful, but at least it is a way for Jesse's impact or input to be heard, and for the court, the DA, to really look at what the charges were, what the underlying crime was, what happened to Jesse, and whether or not the plea agreement is really appropriate in the situation. So just from an attorney's perspective, that is something that we kind of keep in our back pocket for really kind of egregious situations where the plea agreement really does not match the facts of the case.
Is it true that if there's an amendment of charges, the judge has to make a finding under the law that amendment is in the interest of justice? So even if the prosecutor wants to amend this charge in this circumstance down to 2 misdemeanors, the judge, not only can the judge potentially reject the plea agreement itself and the recommendation in terms of sentencing, but they could reject the amendment as well, right? Okay. So, and this is obviously, this is a situation where we're starting to talk about whether the judge is engaged in misconduct under the Code of Judicial Conduct. There are, the commission is limited. We can't enforce the Chapter 950, which is the Victims' Rights statute. We're responsible for Supreme Court Rule 60, but there are some areas of overlap. And you've heard some of the words that Megan's used to describe the conduct of the prosecutor, opportunity to be heard. That's a code provision. So the judge has to provide the parties, or not just the parties, but the people with an opportunity to be heard under the law to exercise that right, if they so wish. So this is problematic in that the judge, delay is tough, adjournments are tough, but the denial of hey, we can just pass this to the afternoon so I can fill out the victim witness statement is problematic from an opportunity to be heard standpoint. And the lack of understanding when it comes to, I don't want to say these words out loud about my sexual assault. And I want to put it in a statement for the court and the parties to consider in this situation. That could be a violation of the code's demeanor provision, the lack of courtesy. towards the victim in the situation. So this is something where if somebody did want to file a complaint with the Judicial Commission, they could. Again, we can't intervene at this point or at any point in the proceedings, but these are the conduct as alleged in this hypothetical is definitely something that we want to take a look at.
Does anyone else have any points where, we could help Jesse access their rights or enforcement options at this point? I think we've covered a couple of the big ones. And
again, I would just echo the prosecutor's unique position if Jesse is not represented by an attorney to be able to assert Jesse's rights on their behalf. One of the rights that I flagged as potentially at issue is that there was no discussion of restitution as part of the sentence. And as was laid out earlier in the scenario, Jesse had been submitting documentation to the district attorney's office for a restitution request. And that is something that the judge should be aware of and should know about, especially at sentencing. But at this point, it hadn't been discussed. I would doubt that Jesse would be in a position to present a complete and full restitution request to the court. So asking for an adjournment, not only to be able to write a victim impact statement, to again have a meaningful opportunity to confer about the plea offer and understand how the prosecutor came to that plea offer, but also an opportunity to prepare a restitution request to submit to the court. Because if Jesse is asked to not only give a victim impact statement on the fly and also submit a restitution request, Jesse's probably not in a position to put forth the best request possible. And the judge may decide to not order restitution in full or not at all. So I would just flag again that restitution is an important right that I think sometimes is, I don't want to say forgotten about, but a last minute thought. And it's something that we should be thinking about throughout the case, not only for purposes of ordering restitution, but for purposes of plea negotiations, that the discussion of restitution is part of that conversation between the prosecutor and the defense attorney.
Great. Those are really important points. Anyone have anything else before we move forward? All right. So in this case, where we have the judge accepting the plea and adopting the sentencing recommendation, this is going to be hard for Jesse. After the hearing concluded, Jesse asked to talk to ADA Doe about what happened, but ADA Doe refused. Jesse called Aaron multiple times after the hearing and the district attorney's office trying to speak with ADA Doe. After getting through to the district attorney, ADA Doe finally agreed to meet with Jesse. When Jesse and ADA Doe met, Jesse asked why ADA Doe agreed to the plea without telling Jesse. ADA Doe told Jesse that they have the prosecutorial discretion to make and accept plea offers. Jesse asked why ADA Doe did not at least warn Jesse that the final pretrial was going to be converted to a plea and sentencing hearing. ADA Doe responded that they had been working towards the plea agreement for months. They just finally had the agreement minutes before the hearing. There wasn't time. Jesse asked why ADA Doe did not make Jesse aware of the plea negotiations. ADA Doe responded that they didn't want to say anything until the agreement was final. Jesse told ADA Doe that they felt betrayed and blindsided by what happened and asked if there was anything they could do at this point to change the outcome. ADA Doe responded that there was not and that they had other meetings to get to and they couldn't talk any further. ADA Doe told Jesse to consider therapy and not worry about Casey anymore. Do we have any additional rights violations?
I would kind of circle back to that foundational right of respect, treating the victim with respect and dignity, courtesy, sensitivity, and fairness. I think being, from this example, the ADA is very dismissive of Jesse's concerns and does not understand why Jesse would be frustrated by the situation, especially, if they're going into it with one set of expectations to be sort of blindsided by a plea agreement. I would also think about potentially reasonable protection from the accused, just in the sense that it's unclear from sentencing whether or not Jesse is going to have any sort of no contact orders that are still in place, giving Jesse an opportunity to pursue other protection options if the criminal case is resolving that they might not have thought of or might not even have, been on their radar at this point. I think that, again, kind of as Anne mentioned, the issue with restitution, but I think back to sort of experiences with these types of cases, and the victim is often, their pathway to get updates about the case, to stay informed about the process, is through the victim witness professional that is assigned to the case. So I think that the ADA here really missed an opportunity to utilize their victim witness professional to keep the victim informed. I think maybe somewhat of a negative view, but I think that the DA is often quite busy. So the victim witness professional is often bears the brunt of, any communications from the victim, keeping the victim informed. So to keep your victim witness professional in the dark really disadvantages them. And it misses out on an opportunity for them to be able to walk Jesse through what's happening. I think at the end of the day, there's that right to confer is not limited to just, it's not just one time, it's not just a couple times, but in my mind, really the goal of that right, or the purpose of that right, is really just to illustrate that keeping the victim in the loop and letting them know what happens is, if they have expressed a desire to stay updated on the case, to my mind, best practice would be to keep them updated on the case, because at the end of the day, I think that I have found that victims really appreciate someone who's straightforward and honest with them, because if they, are blindsided by something, that's much more frustrating to deal with than if they are told, this is what's happening, and are allowed to ask questions and, can walk through the process with somebody rather than just feeling sort of caught off guard and left to wonder what's been going on, because again, they have very little control over this process. So, making sure that they are able to stay in the loop if that's what they want is honestly the least that the district attorney's office can do for them, just so that they know what's going on, that they can have opportunities to exercise their rights, like the right to be heard that was missed out on here, and the right to restitution.
Thank you. And Anne, if I can ask you, I'm going off script, to maybe put on a little bit of your victim witness former life hat. Can you talk about some of the nuances? Obviously, the responsibility lies with the DA's office. And in this case, you have Jesse both trying to contact Aaron, the victim witness coordinator, and ADA Doe. And how, from a victim witness perspective, do you kind of balance that between, they really want access to the ADA, and what can the victim witness coordinator do to kind of placate or provide that information in that interim situation?
Sure. One, I'd just like to highlight, in Marcy's law, the right to confer is the right to confer with the attorney for the government. So I'm just going to emphasize that my read of that is that a victim has the right to speak with the prosecutor. And I know prior to Marcy's law, it was happening a lot, and I think it still does happen, that victim witness is really kind of the front line communication for victims, but they do have a right to speak to the prosecutor. So as victim witness, I would explain to the victim that you have the right to speak with the prosecutor. I would not try to prevent that from happening, but also set realistic expectations for Jesse about what my role is as victim witness. So if Jesse has general questions about the process and wants to be notified of court hearings, I'm not going to ask the prosecutor to do that. I will do that as victim witness. But if Jesse is saying, no, I want to talk to ADA Doe directly so that ADA Doe knows the impact that this has had on me and what I'm looking to see as an outcome, as victim witness, I shouldn't stonewall a victim and say, well, I'll just relay that information. You don't need to speak to ADA Doe, because I think that's potentially a victim rights violation, especially under Marcy's law and now the right to confer with the attorney for the government. Chapter 950 does allow for prosecutors to designate their obligations to victims to victim witness, and that's great. But I think when it comes to conferring, that is something that a prosecutor should be involved in with victim witness. And I would echo what Megan said, that leaving victim witness in the dark on the status of plea negotiations, it really does a disservice not only to your victim witness coordinator, but to the victim, because they're the ones that are having the most communication with the victim throughout the case. I did want to highlight, when it comes to the right to confer, it is a right that a victim has to request. So it's upon request. And I know in the beginning of this scenario, it was laid out that Jesse did not return the victim rights form. That does not mean that Jesse forgoes their right to confer. There's nothing in the statute saying that, or the constitutional amendment saying that Jesse has to fill out that form to confer. I recognize that form is used by the prosecutor's office to keep track of who wants to exercise what rights. But if you're hearing from a victim by phone or in person, things that sound like they want to confer, you need to do whatever you do and protect to make sure that that is documented, whether or not the victim has filled out that form and returned the form. Because if I'm addressing this as a victim rights complaint, that's probably going to be something that I ask either the prosecutor or victim witness is, how did Jesse opt in to exercise this right? And if I hear, well, they didn't return the form, but they did tell me on the phone they wanted to know what was happening in the case, that's going to be an opportunity for me to share a best practice recommendation that if a victim is telling you that they want to confer, and they're probably not using that word, they're saying, I want to know what's happening with the case, I want to know plea offers, that you should know in your head that means that they want to exercise their right to confer, and do whatever you need to do in your file management system to make sure that it is appropriately documented so that the prosecutor and victim witness know that is a right that Jesse has asked to exercise or has opted in to exercise.
Did
I answer your question?
You did. Thank you for humoring me. No, that's perfect. And so does anyone else have any points about potential rights access, enforcement access, referrals you would make at this point? We've talked through a lot of the various resources that were applicable earlier and might be applicable again, but if anyone wants to highlight anything.
I would just like to highlight that I think that was an extremely important reminder that Anne contributed there, that some of these rights are opt-in rights. So it's upon request, the right to, insert right here, that it does not have to be, there is no standardized or required format for opting in, that the victim can do that in so many different ways. And, being aware of that. And I think, Anne made a good point to, be aware of that and then make note of it. So it's in the file. So everyone's aware that, the victim has opted into these certain rights. I personally would recommend that they reach out to OCVS to start the complaint process and talk about the Wisconsin Judicial Commission as an option too. But I think too, thinking about like crime victim compensation, I know we don't have anyone from crime victim compensation specifically to talk about that, but I think that, beyond still being able to pursue restitution, potentially crime victim compensation is also a way for Jesse to address those therapy costs and potentially other costs related to the crime.
Thank you. Any other points?
Sure. This is Julie. I think one of the things that's really important, and Anne touched on this as well regarding conferring, is this idea of there aren't magic words. The statute uses the same phraseology here and there. And so sometimes in the system, we get used to expecting something to be called one thing or another. But the judge also has an obligation before accepting a plea and before pronouncing sentencing to ask the prosecutor on the record whether or not they've complied with the duty to confer. Which again, I think you mentioned this, Anne, but the statutory language specifies that conferring includes conferring concerning potential plea and possible outcomes of the case. So the idea that Jesse's asking for too much in this case, there were several failures the way that this rolled out in the scenario. They had every reason to expect that they would have been given some information about potential outcomes. And also they should expect that the court is asking that question prior to accepting the plea and pronouncing sentence. And that the prosecutor, the ADA, is answering this question, right? So we didn't get into detail in the scenario, but hypothetically, what would have happened was the court would have said, would have asked the ADA, are you compliant with your duty to confer, including concerning possible outcomes of the case, including pleas. So that's another thing to look at. How did the ADA answer that question? And why, after the fact, does the ADA feel like it was okay to not talk about potential pleas?
Yes, thank you. Jeremiah, do you want to say anything to that effect with the judges, or do you want to save it for later?
No, I mean, that's a good point. We start talking about opportunity to be heard. And even if something doesn't neatly dovetail into the Code of Judicial Conduct, it's still a statutory application. It's still the law, right? So that's the first thing when I'm looking at these, the extent that we do get complaints from victims, that question and answer from the prosecutor and the ADA, and whether there's any back and forth or any nuance to it versus like, did you do the Marcy's thing? Yup. If I'm looking for more detail there, I really am. But it's something that, regardless of whether it falls under our jurisdiction, it's still a statutory obligation.
Great. Well, if folks don't have any final thoughts about this part of the scenario, I would like to backtrack a little bit and hear from our last panelist, Julie Brown, to give her introduction before we go into the break. So if we can switch back to that slide, I will turn the floor over to Julie and she can give you a little bit of information about herself.
Well, thank you. And again, my apologies for not being there at the top. We had some technical issues and our IT people jumped right to it. So I'm happy to be with you, even without video. So I'm the operations director of the Crime Victims' Rights Board. The board is a state victims' rights enforcement body. There are 5 members, and they are by statute appointed by different authorities, including the Attorney General, the Wisconsin District Attorneys Association, the governor, and the Wisconsin Crime Victims Council. The board became operational in 1999. It reviews victim rights complaints filed by victims against public officials, public agencies, and public employees. And since 2017, that does not include judges. Many of you may know, as of 2017, the Supreme Court ruled that the statute under which the board operates was unconstitutional as applied to judges. But between 1999 and 2017, the board did review cases involving judges. Today, the way it works is the board may refer possible victim rights violations by a judge to the Judicial Commission if they choose. So the board is concerned with the protection of victim rights, obviously, but a little bit different than some of the other enforcement mechanisms we're talking about today, because it's not a victim advocacy body. It is an objective fact-finding body. So the interests of all parties involved in a complaint are protected equally throughout our system. There are 3 of us at DOJ assigned to help the board in what's called an administrative attachment to the Department of Justice. So in addition to myself, we have an executive assistant and an assistant attorney general assigned to the board who serves as legal counsel to the board. This limited administrative attachment then allows the board to function and supports operations, but the board's decisions are independent of the Attorney General's office, and those of us who are assigned to assist the board are not decision makers in cases. The board then has an authority and jurisdiction, and it's all through statute and administrative code. It is limited and it's narrow. The board determines whether violations occurred, and they can issue sanctions for violations. There's also a separate authority to issue reports and recommendations about the provision of victim rights and services. And I'm sure you already went through this, Anne, but a victim can only seek review by the board after going through the complaint process with the Department of Justice Victim Resource Center. Once they've gone through that process, then they're eligible to file their complaint with the board. I did upload a brochure, so there's more detail in that. And then, of course, later in this presentation too, when we go through the scenario, we'll get into a little bit more detail of what this looks like in practice. Thank you, Morgan.
Perfect. Thank you, Julie. Well, we are shockingly right on time. We are actually going to take a 5-minute break. So this is the stretch bathroom break. We will convene again, let's say at 10:50, and we will pivot from walking through the scenario more to really getting into some of the nuances of the procedure for how the victim can access any of these rights. And we've talked around what some of these offices do, but we're going to learn more about that. So please join us again in 5 minutes and we will get going. Thank you. All right, I think we are going to get going again. I see we lost a handful of people at the break. Hopefully they will be rejoining us because now's when things are going to get really exciting. We are going to talk about the enforcement options. So at this point, I'm going to turn things over to the panelists to talk about the work they do and where they could have intervened specifically, or their colleagues in the scenario that we walked through. How could Jesse have been helped at various stages in this process? Megan, I think we're going to start with you.
All right, thank you, Morgan. Just kind of from the victim's rights perspective, I wanted to kind of approach it from two different ways. I feel like in this case study, this fact scenario, there's a really critical moment of the final pretrial where things kind of fell apart for Jesse related to their rights, when that final pretrial turned into a plea and sentencing. So I wanted to approach it in two different ways. If we were in a hypothetical situation where Jesse had an attorney from the time charges were filed, versus if Jesse had gone ahead with retaining an attorney after sentencing, potentially after meeting with the DA's office, to really talk about Jesse's options and what that might look like for Jesse at this point. So in the, non-reality world, or, taking a step back, pretending we have a time turner and can go back in time before the plea and sentencing happened. If Jesse had gotten an attorney when or around when charges were filed, that could have changed the situation. I will put the caveat on there that it also might not have, just because you have an attorney as a victim, that does not mean that I have a magic wand and can make everything go perfectly. At the end of the day, it is still, there is still prosecutorial discretion. It is still up to the prosecutor to make decisions about what charges to file, what pleas to make, what pleas to accept, things along those lines. But often my goal is to really help communication between the victim and the DA's office, really help facilitate the victim's interactions with the DA's office or with victim witness. I have often found a lot of wonderful victim witness professionals out there who can kind of help keep me and the victim in the loop. And I will say, and I forgot to mention this earlier, but I use the term victim. We're all using the term victim just because that's the legal term. But as I often will tell my clients, or put that out there for my clients, that if they prefer to use something else, if they would like me to say something else, that I try to be respectful of that. Because while that's the legal term, that might not be something that they're comfortable with. So I tend to start off whenever I'm retained on a case, really trying to either write a letter or, send an email, depending on my relationship with the district attorney's office, letting them know that I'm involved in the case, that I've been retained by the victim. That is typically, they have these requirements to notify the victim about hearings and things like that. So I just try to let them know that, what my expectations are for their role in the case. So please continue to send notices directly to the victim, and I just tend to ask that they copy me, especially if there's emails or anything like that. They just copy me. I don't want to kind of be a barrier or put up a roadblock between the victim and the victim witness professional, because we do offer different services. We bring something different to the table. So I want the victim to be able to continue to access those resources. And I also, in that kind of initial communication with the DA's office, I try to talk about what my role or what they can expect from me, essentially, letting them know that I'm really there to help my client, the victim, enforce their rights throughout this process. I try to raise any specific concerns that we have, or, for example, if Jesse has communicated with me that, I do not want a plea that has no prison time. I want some sort of incarceration. That is sort of a non-negotiable for me. Making that clear to the DA's office, putting out there, communication opportunities, meetings, things like that, to try to stay connected and try to get ahead of what happened here with the DA doing these plea negotiations behind the scenes and not really keeping anyone else in the loop. So the goal is to try to avoid that, but reality is that may or may not be possible. This DA could just, have their way, and regardless of whether or not Jesse has an attorney, they might just go forward as planned. So the big role, and usually what I often tell my clients is that as their attorney, I'm here to advocate for their rights. And within the criminal case, they have a specific set of rights that are laid out in the statute and in the Constitution. And these rights, as listed in the Constitution, start at the time of victimization. So before charges are even filed, these rights are there. So as Ann mentioned earlier, those rights to get notified about their victims' rights, that happens, at the law enforcement stage. That is not limited to after charges are filed. So my goal is always to work with the victim to try to accomplish what they want. And letting them know that I am there to help them use the law to accomplish their goals. I, will do whatever we can within what is legally possible, and trying to really make sure that they understand that we're kind of working together, that I want to work with them to accomplish their goals, that I'm in their corner. I think that a lot of, especially district attorneys and victim witness professionals that I've worked with or advocates, they have a lot of good intentions. Typically, they want to help the victim. They want to prosecute these crimes. The issue is that, they can't give legal advice, or, they might have other considerations that may outweigh the victim's wishes. So it's important for me that the victim understands, or my client understands, that I am really the only one that's solely in their corner. I care about the case insofar as they care about the case, but I don't care about the outcome. I'm not the one presenting evidence. I'm not the one making the case to the jury. I am not the prosecutor. At the end of the day, I'm not the prosecutor. I cannot do those things. I honestly don't want to do their job. So making that clear to them, but also clear to the prosecutor's office. I do not want to step on your toes, but I am here to help my client enforce their rights. So I think about, in this case, really, whether that is through the form, the CR 296 form, the request for enforcement of victims' rights, or through a separate filing or separate motion, to really make sure that the court understands that Jesse wants to be heard on these issues, that Jesse wants to be involved in the process. If there are requests throughout the case, that, I'm there to help to make sure that Jesse's voice is heard, and really helping victims sort of regain their control, regain some autonomy throughout this process, because as I've mentioned before, they have very little control of what happens. So, that right to be heard, that right to confer with the attorney for the government, their rights are helpful, but they are limited. They do have a very limited role in these cases. So I really want to be able to make the most of that and really utilize the rights that are available to them in the Constitution and the statutes to help them accomplish their goals in whatever way possible. And to step away from Jesse's example for a second, that can go both ways. I have had it where my client disagrees with the prosecutor and wants something different, and I've worked with the defense to help get a bond modification that's in line with what my client wants, because the DA's office isn't on board. So it does go both ways, and really trying to help the client accomplish their goals in whatever way legally possible. So turning then to, the reality of this case study, and now that plea and sentencing has been done, if Jesse were to retain my services, what would that look like? What could that look like? So it's not on the slide, so I apologize for that, but thinking about restitution, there are guidelines in the statutes for restitution. That is typically something that should be included as part of plea and sentencing, but if it's not, that does not mean that Jesse has no more options. That is something that I have helped clients with before in pursuing restitution after plea and sentencing if it wasn't dealt with ahead of time. I have one that's still ongoing now, that's been going on for a couple of years. Plea and sentencing is done, but we're still working on restitution. So that is something that, is still open and available to Jesse. So helping them pursue those restitution options, making sure that they, if they can't go back and undo the plea and sentencing, that is never going to be an option for Jesse. But to at least get the financial compensation for, the therapy or any really losses that result from the crime. That is a really important part that an attorney can play for Jesse here. The second kind of part of that, or where an attorney can really play a role, is getting protection from Casey. Again, it's not clear in the plea and sentencing what that looks like. If Casey's on probation and has no contact orders, or, whatever that might be, helping Jesse consider their, restraining order / injunction. People tend, by people I mean clients, tend to think of it as a restraining order. But that process is not limited by what's happening in the criminal case. And that is not something that's limited to after sentencing either. I often recommend considering an injunction, even if there are no contact orders in a criminal case, because you never know when that's going to go away. Those no contact orders could go away if the case is dismissed unexpectedly, if it's resolved unexpectedly, and just getting ahead of that, getting an injunction in place is always something that I recommend as an option if my client is concerned about their safety from the defendant, because they have that reasonable protection from the accused as one of their constitutional rights. So once we're sort of outside of that criminal court process, one way to get that protection is through the restraining order or the injunction. And in this case, given the history with Jesse and Casey, that they did have a dating relationship, I recommend the domestic abuse injunction. It's something that it fits the situation. It tends to be something that is a little bit more protective in my mind, just that you don't have to pay for the fees, but also domestic abuse injunctions tend to come with the firearm restrictions and I apologize, I can't remember if the plea included felony charges. I believe they were knocked down to misdemeanors. So being able to remove those firearms to be able to kind of help ensure safety too with the domestic abuse injunction, it could be a helpful path for Jesse. And then my biggest step, or my kind of biggest default, is making referrals to other agencies to go the next step. If Jesse is feeling still frustrated by what happened, feels like they just want something to be done about it, even if they understand that they cannot go back and undo the plea, they can't make the sentencing go away, letting them know that there are options for them to raise the issues about what happened, for that to be looked at by somebody else, even if it doesn't change what happened in their case. Oftentimes when I refer clients to like Office of Crime Victim Services and that complaint process through to the Crime Victims' Rights Board or Wisconsin Judicial Commission, what's important for them is that they don't want this to happen to somebody else. So they want to make sure that the people who are responsible for their rights violations, at least that there is some accountability, even if it's through somebody at least knowing that this happened, so that hopefully it does not happen to somebody else. So just to kind of, as a starting point, I often refer to Ann in the Office of Crime Victim Services, so I can turn it over to Ann to talk a little bit about what that process looks like for Jesse.
Thank you, Megan. So I know that I've talked about the informal complaint process, and Julie has talked about the Crime Victims' Rights Board. So I just want to start my session here talking about the process so that folks who potentially may be the subject of a victim rights complaint know what to expect, and so that folks know how to appropriately refer victims to this complaint process. So as Julie mentioned in her introduction, the victim rights complaint process, in order for a victim to file a complaint with the Crime Victims' Rights Board and the board to be able to take action on that complaint, a victim needs to go through what we call the informal complaint process first. So working with a victim rights specialist in my office. There are 3 of us that handle victims' rights complaints. So it's not just me. And there's an individual in our office who does a lot of the triaging. So she's the one that's answering the phone most of the time and responding to emails and inquiries from victims that potentially have a victim rights complaint. And so I said in my introduction, and I think it's just important to remember that the victim rights complaint process in itself is a right. So in 950 victims, it says victims have the right to complain to the Department of Justice concerning the treatment of crime victims and to request review by the Crime Victims' Rights Board of the complaint. So again, this isn't just something that's a courtesy to placate an upset victim. This is a right that they have. And I think it really dovetails into the right to be heard. Although it's not me intervening in a court case, it is an opportunity for a victim to tell the system what worked and what didn't work, and an opportunity to be heard about how it felt when this happened or this didn't happen. So again, it is a right that victims have to complain to DOJ and to request a review of the complaint by the Crime Victims' Rights Board. So I know that nobody likes to be complained about, but I just encourage you to think of this, if you're contacted by our office about a victim rights complaint, as a victim exercising their right. And I just ask that you participate in the process and keep in mind that a victim is exercising their right. And this isn't just an indulgence to, again, placate the victim and make them feel like, oh, yeah, you call DOJ, like, good for you. No, this is a right that they have, and they can assert their rights in court. And I know that we talked about that a little bit earlier. So when we talk about the informal complaint process specific to Jesse's situation, I think it's really crucial to kind of break down at what point Jesse would be contacting our office, because that's really going to decide how I address the complaint. So a general overview of the informal complaint process is that we receive complaints from victims and witnesses. I want to highlight this because this is a little different than the Crime Victims' Rights Board. Witnesses also have rights in 950, and DOJ has the authority to receive and act on complaints made by witnesses. The Crime Victims' Rights Board, Julie will talk about this later, can only receive complaints from victims, or I shouldn't say only receive complaints. Their actions are limited if they receive a complaint that is not signed off by a victim. Whereas in the informal complaint process, I have a little more latitude when it comes to what I can do to address a complaint if it's from a witness. So again, witnesses have contacted our office with complaints related to not being notified of the cancellation of a hearing that they've been subpoenaed for. That's a right that they have that I've addressed. So again, not only can victims call DOJ to complain, but witnesses can as well. So for Jesse's scenario, if Jesse were to have contacted DOJ, let's say the scenario was a little different and Jesse learned about the plea agreement prior to the final pretrial hearing, let's say the day before. And Jesse was referred to our office and had a complaint that, like, I don't feel that I've been heard. I don't agree with this plea offer. What can I do? What I may do is address that complaint by contacting the prosecutor and asking for the prosecutor to request a continuance on behalf of the victim. I also may empower and encourage Jesse to speak at the plea hearing. I know that Bob Kaiser put in the question and answer box a reminder that victims now have the right to be heard at proceedings at which their victims' rights are implicated, and that would include a plea hearing. So Jesse may say, I don't want the prosecutor to tell the judge that I want to continue, and I want to tell the judge that, and I want to assert my right to be heard and assert my right to confer. So part of my process may be providing Jesse with some information about how to go about doing that. And it may include contacting the prosecutor to make this request to prevent the potential violation from occurring. Now, if Jesse were to have contacted us later in the process, so after the plea and sentencing happened, my role is a little bit different. At that point, I would say what I would be doing is contacting the subject or subjects of the complaint to address what happened and why it happened. As Megan said, I can't undo what has already happened. There's not going to be, a do-over for the plea and sentencing hearing. So really my role at that point is to relay to the subject or subjects of the complaint that Jesse has, and gather information about why certain things happened or didn't happen. And then once I've completed that, what I would then do is go back to Jesse and inform Jesse of the outcome of the action that I took regarding their complaint. So providing them with a summary of the people or agencies that I contacted to address the complaints and the response that I received to their complaints. And for some victims, they already know why things happened or why they didn't happen. So this can unfortunately feel repetitive to victims, but a lot of times victims find value in, like what Megan said, having their complaint be heard to prevent something like what happened to Jesse from happening to a victim going forward. The folks that I hear from are incredibly resilient, kind, caring individuals that contact our office. And I would say most of them say, I don't want what happened to me to happen to somebody else. And I think that's really brave and insightful of somebody to say when the system feels like it failed them. So making sure that their voice is heard through this complaint process is a big part of what I do. Our process is victim-led. So we will not act on a complaint if it comes in, like, for example, from an advocate. Let's say Jesse was working with an advocate and the advocate witnessed kind of what happened at the final pretrial. And the advocate is outraged on behalf of Jesse. And the advocate calls and says, I want to file this complaint on behalf of the victim. We would need the victim's permission and we would need to speak to the victim in order to move forward with an informal complaint. And kind of related to that, if Jesse reaches out to us and we learn through kind of our triage process that Jesse's represented by an attorney, we would need to seek permission from that attorney to communicate with Jesse and take action on the complaint. So in this triaging process that's done when a victim or a witness contacts us, we're gathering information about what their complaints are, helping them identify if those complaints are related to a victim's right, either a statutory right or a constitutional right. But then we're also kind of having to ask questions about, are they represented by an attorney? Who is that attorney? Does that attorney know that you've contacted our office? So that we can make sure that we're in a position that we can address the complaint. Obviously, we're part of the Department of Justice, so we want to make sure that we're not stepping on any toes when it comes to individuals that are represented by an attorney. So again, we would seek the victim's permission, and if they were represented by an attorney, their attorney's permission to act on the complaint. We can't really act on an anonymous complaint in that how we would address that complaint would be very challenging. So a victim could contact us and say, yeah, I have this complaint, but I want to remain anonymous. Becomes incredibly challenging for us to ask the subject of the complaint to appropriately respond to the complaint if they don't know the case, if they don't know who the victim is and what the complaint is. So in part of the triaging process, we're talking to victims about safety concerns or concerns if they're concerned about retaliation for filing a complaint. Those are all conversations that we're having kind of before we decide to move forward on a complaint. Sometimes we have victims that contact us and we talk to them about the assistance that we can provide through this informal complaint process. And their case is still open and ongoing, and they make an informed decision to not pursue a victim rights complaint at this time, and that they will circle back to us once the case is closed. That happens, and we always, like I said, leave it up to the victim, and that we are victim-led in this process. So in this informal complaint process, what it is it's a lot of back and forth between the victim and myself and the subject or subjects of the complaint, relaying information from one party to another to, again, advocate for something to happen or to stop happening, or to gather information about why something did or did not happen. Through this informal complaint process, there is confidentiality around these complaints, but I do have the authority and the ability to inform the person that's filed a complaint, so the victim or the witness, of the outcome of any action that I have taken on the complaint. And procedurally, usually how that works is after I talk to the subject or subjects of the complaint, I will call the victim to let them know, hey, this is the conversation that I had with ADA Doe and victim witness coordinator Aaron or Officer Schmidt, to let them know what the response is that I received. And oftentimes in that conversation, there may be things that come up that I need to follow up on, whether it's a question that a victim has that they didn't think of in the beginning, that they are seeking clarification to or response. So then I may have to go back to the subject of the complaint and say, we talked last week about this complaint, but the victim has a follow-up question. And again, gathering that information on behalf of the victim. So if you find yourself being contacted by our office for a victim rights complaint, there may be some back and forth to address the victim's complaint or concern. So don't be alarmed by that. I have worked on victim rights complaints where, just due to the type of complaint it is and communication issues, I have been on like a conference call or gone and met with a victim and the subject of the complaint in person. So it can feel like a mediation, but I stray away from using that word because it has very specific meanings, depending on what sort of process you're involved in. But I have found it to be a great opportunity for victims to sit face to face with prosecutors, victim witness, law enforcement, clerks of court, or be on the phone to relay directly to that individual what their complaint or concern is. So there is always that option of there being like a conference call or a meeting. And you'll hear from Julie a little bit later that her process is different about how complaints move through the Crime Victims' Rights Board. But I just think it's important to highlight that every complaint that comes to our office is handled in a way that we receive the complaint, we receive victim's permission to address the complaint, we address the complaint, and we inform the victim of the outcome of the complaint. But how it works as far as communication can really vary depending on a lot of different factors. When it comes to me closing out a victim rights complaint, again, I will have had a conversation with the victim saying, this is the information that I learned from the subject of the complaint that you identified. What I do then is I write a closing summary letter. And this letter is addressed to the victim. And it's, again, summarizing the complaints they contacted DOJ with, the folks that I contacted to address the complaint, and a summary of the information that I gathered or the action that I took on the complaint. The records of the Department of Justice are confidential unless the subject of the complaint waives confidentiality in writing. So that means this letter doesn't go to anyone but the victim. And again, complaints in themselves are confidential up until a certain point. And I don't want to speak for Julie's process, so I think she will talk about that. But as part of our process in the Office of Crime Victim Services, we value and respect a victim's privacy, but we also understand the importance of these complaints when it comes to a subject of a complaint, that we are not going to do things to unnecessarily, we're going to try to avoid any sort of unnecessary embarrassment related to the complaint. If I have to contact, let's say the complaint is about a prosecutor, but it's important for me to contact the victim witness coordinator to get some foundational information about what victim's rights the victim had asked to exercise. Part of that conversation is going to be asking that person, the victim witness coordinator, to not share the subject of the complaint or that the department is reviewing a complaint related to the prosecutor. So again, I recognize, as coming from a district attorney's office, it is not fun to be contacted and told that somebody's complaining about you, but we really do, one, value a victim's privacy, and two, value the work that you do. And again, understand that these complaints, we're not in a position we're going to try to embarrass you, make them public, anything like that. So as far as next steps in the complaint process, once I've concluded that closing summary letter, I provide that to the victim. That includes a complaint form for the victim to fill out if they choose to go to the Crime Victims' Rights Board. One thing that's important to note is that just because a victim engages in the informal complaint process does not mean that they have to pursue a complaint with the Crime Victims' Rights Board. It's not automatic. I'm not just shipping complaints to the Crime Victims' Rights Board. Again, a victim would have to fill out that complaint form to engage in that process. So I will now turn it over to Julie to talk about what we call the formal complaint process, or the Crime Victims' Rights Board process. Thank you.
Thank you, Anne. And just to tag on to the last thing you said, in fact, most people don't file with the board. The vast majority of complaints that come in through DOJ are resolved and finished at that stage. Okay, this slide, just quick review again, that the board operates by the authority of the statute. So the board is following those rules in the way that the process is set up. It's a fact-finding body that can issue sanctions for violations, and it acts independently of DOJ. Okay, slide. So let's walk through, given our scenario today. In our scenario, Jessie would use the form that she got from Anne after completing the informal process with the DOJ Victim Resource Center to file the complaint. Their submission then would be reviewed to make sure it's properly before the board. If it's incomplete, we would reach out and we would let them know what's needed to properly file their complaint. So Jessie might be selective about what they include in this complaint. Chances are there were some issues addressed in the informal process that wouldn't be included in the formal complaint. Perhaps some things that they were upset about, but don't implicate a victim right. But, and this is important, Jessie doesn't have to be a lawyer to write their complaint. So if they include things over which the board does not have jurisdiction, along with some victim rights issues, that's going to get sorted out. We have a fair amount of communication back and forth throughout this process, and the board's decisions are all put in writing as well. So we would talk about that. So let's say an issue that was addressed in the informal process is beyond the jurisdiction of the formal process. That's going to become clear to Jessie as the case moves ahead. So as an example, maybe they submit a complaint that they didn't like the terms of the plea, that they didn't get to confer about the plea, and they think sex offender registration should have been included in the sentence. Well, some of those issues are going to fall out of a formal complaint because they don't implicate a statutory or constitutional victim right. And again, that's all going to be explained if that happens. So when Jesse files the complaint, I'm going to check with the Victim Resource Center and make sure that that process was completed. And then I request from the VRC a summary of the process and outcomes of the informal complaint. So this is not a handing over of like Ann's case file and communications and all that stuff to the board. It's exactly those words I just said. We ask for a summary of the process and the outcomes. So we get a very high level summary, enough to help me verify that the issues and the people that were noted in Jesse's formal complaint were addressed in the informal complaint. Our system is set up here as a two-tiered system so that everybody has the opportunity to try to resolve this during the informal process. So if they weren't, Jesse will be told that they need to re-engage with the Victim Resource Center on any of those issues, and that part of the complaint might be remanded then back to the VRC. And as Ann mentioned earlier, it's victim-led. They don't have to. They could say, okay, we're gonna drop that one and move ahead with the other issues, or they could go back and go through the informal so that whatever that issue is can then move forward to the formal realm. So assuming now that Jesse's complaint is properly before the board after that first stage, the respondents are going to get a copy and a notice of the complaint, and they'll be given an opportunity to submit a written answer to the board. They don't have to. They can if they want. And you know what I should mention too, sometimes complaints come in directly from victims, and sometimes victims are represented. And I'm hearing from an attorney, or an attorney is filing the complaint on their behalf. So sometimes it's sort of straightforward where you've got one complainant and one respondent, and sometimes there are a whole lot of people and their attorneys involved in the complaints. Works fine either way for us. So let's say Jesse includes a complaint about the judge. The board might decide to refer that portion of the complaint to the Judicial Commission, or it may just dismiss that issue because they don't have jurisdiction over judges. But Jesse's complaint about not being conferred with about the plea, that would be sent to the ADA in this case, and then that ADA would have the chance to submit a written answer. And if they submitted a written answer, Jesse would get a copy of that. So the first big decision in a case review is the board's probable cause decision. It is not a finding of wrongdoing. It's simply a determination that there's enough in the complaint to justify a further, more in-depth review of the complaint. You see the red line there. So I want to note that up to this point, everything by statute related to the complaint is confidential. That is until a probable cause decision is made. And then things are subject to the open records balancing and sort of the usual with the public records. So the probable cause decision is really the first big hurdle, if you will, in a complaint. To make the decision, the board reviews the complaint, the answer to the complaint if one was submitted, and then that summary of process from the Victim Resource Center. If the board feels Jesse's complaint in this case lacked probable cause, they would get a final decision saying that. So if there's no probable cause, the case is dismissed, and that is a final decision. And so Jesse would get that decision in writing along with their appeal rights. If the board finds probable cause, then they can choose to look into it more. By statute, they can't do any of those things having to do with investigations until or unless probable cause is found. So after a PC finding, the board might conduct an investigation. They might hold an evidentiary hearing or request additional records. It just depends what kind of information they need to fully review the issues in the complaint. after all of that, whichever route it goes. So, hearings, I'll just say real quick, are less common, but they do occur. Usually it's a matter of gathering records and maybe a couple of interviews to fill in some gaps on any material issues that the board needs to decide on. So the board makes a final decision. Like everything else with the board, it's put into writing. If a violation is found, the board can issue a sanction. Again, there are appeal rights for all parties. An appeal could include a judicial review of a board's decision. There have been several judicial reviews, and sometimes that's the end of it, and sometimes they keep going. Each decision gets appealed and they go through the courts. So that's how the Supreme Court decision came about whether or not the board can sanction judges, by the way. Okay, slide please. So what action can the board take after a review? They can issue reprimands. They can be private or public. We mentioned briefly before, there's something called equitable relief, which is not well defined, but the way it's been used in the past is the board seeking to communicate the issues at hand, get somebody to do something or somebody to stop doing something in order to prevent a violation from occurring. The board can bring civil actions for forfeiture of up to $1,000 for intentional violations, and they can refer something involving a judge to the Judicial Commission. That is the only thing referring to the Judicial Commission that they can do with regard to things that come in related to judges. There's also something that Anne alluded to. I would call it a limited action case. And this is where, because of something having to do with the filing rules, the board can review a complaint, but they're limited in the actions that they can take. So Anne gave the example of somebody not consenting to or signing the complaint. That limits what the board can do with it. And then there are also some timing issues to keep in mind. So if something is filed later than 3 years, more than 3 years after the conduct that's being complained about, the board can still review it, but they're limited in what they can do should they find a violation. And what they're limited to is actually our next slide. So let's go there. Reports and recommendations. This is a separate authority of the board. They can be issued because of the case. They can be issued independent of a case. Sometimes the board has seen a number of cases around a similar issue, and then they've issued special reports and recommendations to talk about the provision of rights and services. They're often used for training. Sometimes advocates have said they use them in casework in order to push for compliance. Officials sometimes review these in order to just understand how the board has ruled or interpreted certain rights and duties. They're all online. They use non-identifying information so that they can be shared widely. So let's say the board found a violation in this case against the ADA. They can do any of these things or a combination, right? So they could have issue a private reprimand, but they might also, in addition to that, issue a report and recommendation, because these provide the opportunity to share the lessons that are learned in Jesse's case without identifying any parties. And as for that judge, maybe the board decides then to refer that portion of the complaint to the Judicial Commission, which brings us back to Jeremiah to explain how that would work.
Julie, I'm going to talk a little bit about the Judicial Commission and its operation. The commission is it's authorized by statute. The Wisconsin Constitution gives the Supreme Court the ability to impose discipline against judicial officials in a manner set by the legislature. So the cases ultimately go before the Wisconsin Supreme Court, but the legislature set the ground rules, created the commission, and it created the commission as an independent agency within the judicial branch. What does that mean? Well, the court system, the Supreme Court, is neither responsible for the position or funding authority of the commission. So there's no allegation that the commission did or didn't do something based on any concerns relating to the court system. Likewise, they don't have to make funding decisions, which could be seen as problematic based upon our review of a particular complaint. So it's the best for the court system in that regard. The court system itself, the Supreme Court appoints two judges and two attorneys to the commission. And the governor's office appoints five members of the public. Actually, right now we recently had a 37-year retired victim witness coordinator, 37 years of experience in the business, has recently come to the commission as a public member appointed by the governor. So it's nice already to have her perspective on the work that the commission does. We are not, as I mentioned before, we're not an appellate court. We're not a second bite at the apple there. And we don't deal with a complaint that we do get all the time from victims and other stakeholders, which is a dissatisfaction with the length of the judge's sentence. The judge's sentence wasn't long enough, didn't fail to take into proper consideration the words or wishes of the victim in a case. And in Wisconsin, judges do have a broad degree of discretion under the law to craft sentencing remedies, with a few exceptions. We're not a state. I used to practice in Florida, and in Florida there were sentencing guidelines. So you could say within 0.10 of a month exactly how many months somebody would serve, or the range that they would serve. So it's a little bit different in Wisconsin. We don't handle those, but we do handle several complaints that overlap with some of the issues in Chapter 950. If you could please move on to the next slide. Thanks, Megan. As I mentioned earlier, there are nine appointed commissioners. The majority of those commissioners are appointed by the governor's office. I hope to be, I saw a note about how if I'm going to go till 12, and I apologize, I'll try to get this aspect of it done in 10 minutes or a little bit less. We have two staff members, so we don't have a huge staff at the Judicial Commission. We review those complaints, as I mentioned, concerning the Code of Judicial Conduct. And it's not just in juvenile or criminal matters. So there could be a situation where a judge might mistreat somebody that could be considered maybe a victim in a colloquial and not a legally defined sense. And that's something that the commission would consider as well. Criminal cases are our number one referral in terms of types of cases that the commission considers, but we also handle a lot of domestic relations cases, family court cases, harassment, injunction cases, and all types of cases under the sun, probates, civil, you name it. So that's Supreme Court Rule 60. And if you want to take a look at 60, that's going to be accessible on our website. And there are some areas of common overlap that I touched on briefly with the circumstances relating to Jesse, where there's a requirement that a judge exhibits patience, dignity, and courtesy towards those that appear before the judicial official, and then opportunity to be heard shall afford that person, every person with a legal interest, the right to be heard under the law. So to the extent that issues come up in criminal cases involving victims, these are typically the two provisions that we are going to be looking at and reviewing. And just as a side note, we talked about the sentencing, the length of sentencing, the judge's legal ruling itself. Just because you disagree with that ruling, that doesn't necessarily mean that it implicates the demeanor rule. Some of the things that Judge Dracoff did, that just not understanding why the victim just couldn't speak up already, even though that's about the sentencing process. That would be something that we'd want to definitely take a look at in terms of a lack of sensitivity or courteousness to the victim involved. Megan, could you go to the next slide, please? All right, so the process itself, just a few general notes, as I am a broken record about it, but we cannot intervene in court proceedings. Our proceedings, at least until the filing of a public complaint, what occurs in the process are confidential. A complainant, whether that's a victim, an attorney, a member of the public, somebody that watched a hearing over Zoom or YouTube, anyone can file a request for investigation. There's an initial threshold determination made by staff as to whether the complaint is within the jurisdiction of the commission and not solely based upon speculation. If it meets that threshold requirement, the staff, which is typically myself, would be taking that complaint to the commission, the 9 members of the commission, for their review. They would make a determination about whether or not an investigation should be authorized in this situation, depending on the substance of the allegations, the substance of the investigation. The commission may or may not appoint either an investigator, outside counsel, to handle a review of a situation. A lot of times we're looking at transcripts or hearing recordings, so we might not need to hire an investigator at all in that situation. During that process, the commission is required to consider at several stages. The judge has a chance to be heard in our process. We talk about opportunity to be heard. The judge has an opportunity to be heard in our process. And depending on the circumstances, we may invite the judge to appear before the commission in a formal or informal appearance. At the conclusion of the investigation, the commission will decide whether to dismiss a complaint, dismiss it with an expression of concern or warning, or file a public complaint in the Supreme Court. Next slide, please. Thank you. At that stage, the confidentiality of the proceeding ends. It's public at that point. If a public complaint is filed, a panel of appellate court judges preside over the case. The trial court, that's the judicial conduct panel. It's different for every complaint. So it's an ad hoc committee. It's 3 Court of Appeals judges. They act as the trial court in the case and will, if there is, sometimes the cases are decided based on stipulations, based on a review of transcripts, because there are no factual disputes. Sometimes there are trials. We had our most recent trial in 2019. All of the ones before or since then, at least in recent memory, have been decided based on briefs and based on court documents that weren't being disputed. There might have been arguments about the law or the application of the Code of Judicial Conduct, but they were resolved absent a trial. At the conclusion of that hearing, judicial official will, or the judicial conduct panel will issue findings and a recommendation to the court. Then the court will make a decision. Will they accept those findings? If there's a finding of misconduct, will they accept the recommendation in terms of sanctions, whether it be a reprimand, a censure, which is basically the same thing as a reprimand, suspension of the judge without pay, or removal from the bench. And they will determine whether there was misconduct. They'll conduct that review, and they will impose a sanction if that's what they would like to do. And they will do so in a public order. Actually, our most recent case where there was an opinion issued this summer involved some issues that dovetail well with the some of the issues with the conversation that we're having here today. There were among the allegations, and there were 6 allegations relating to 6 separate incidents, but one of the incidents involved the judge's comments that were insensitive to a domestic violence victim, and another one involved the judge's comments that were insensitive concerning a victim of sexual assault. So that is a case that if you look on the commission website, you can see a link to that opinion. I would recommend reading it if you're thinking about what the commission does in the context of victims' rights. And I would encourage you, if you're not sure, go ahead and file a complaint with the commission, and we'll take a look at it and let you know how the process goes and inform you of the results of that process. And at this point, I'd like to thank you for your patience with me going through what can be the Byzantine process of the commission complaints. And I think I'm passing the ball back to, or the baton back to Morgan to lead questions, if anybody has any questions for myself or any of the other panel.
We do have questions. So thank you to everyone for giving us all that insight. I think especially when we talk about the Crime Victim Rights Board and the Judicial Commission, there are these mysterious entities that people don't necessarily know how this works behind the scenes. So I think that's particularly informative. We have first a question that's pretty brief in the Q&A here, and this would be for Megan. Can the victim rights attorney assist in the TRO and represent at the injunction hearing? You mentioned safety concerns and injunction needs that Jesse might have. What would be the role of the victim rights attorney in that case?
So I'm hoping you can't hear the loud truck outside my window. Yes, short answer, yes. The victim's rights attorney could likely help with actually going through the injunction hearing and that whole process. It is something that is dependent upon, eligibility, which for our project is really doesn't have income or asset limits. So it's really more of, is there a conflict or not? And then helping the victim is dependent also upon our resources. But I think the biggest thing that I always try to recommend is that if you are hoping to get legal assistance with a restraining order, that you apply before filing, because the turnaround is often very tight from the filing to the hearing date. So getting someone on board early, i.e. before filing, is a great way to make sure you have an attorney available for the date, and also to make sure that the forms are filled out correctly and that the petition is thorough. I think a lot of people don't realize that whatever you include in the petition is what you were limited to testifying about at the hearing. So really making sure that it is a well laid out injunction paperwork, injunction petition, so that the victim has the best likelihood of success at the hearing.
Great, thank you. And then we do have a few questions from the app. So people figured out how to submit the questions there. That's great. One of them, is there a time limit to file a complaint with OCVS, the CVRB, and the commission? Or I think another way would be, are there statute of limitations that people have to be concerned about with complaint processes with any of those entities? Anne, do you want to start with OCVS? We'll just go down the list.
Sure. Yep. There is not a statute of limitation for a victim or witness to file a complaint with DOJ, Office of Crime Victim Services. But for Julie, there is, and I'll turn over to her to talk about that.
Sure. You can file. What's limited is what the board can do with what you file. So if you're filing something more than 3 years after the conduct that you're complaining about, then the board can take it and still review it, but they're limited to only being able to produce a report and recommendation from that.
Thank you. And Jeremiah.
Sure. With the commission, there's no explicit statute of limitations for the commission, but the age of a complaint, especially if it's an issue that was known to a complainant a decade, 2 decades. I received a complaint from a conduct in 1979 last week. The age is something that the commission considers when determining how to proceed going forward, but no statute of limitations.
That person is still upset from 1979. So it just shows that the way people interact with the court system sticks with them. Next question, generally, what if the victim doesn't have an attorney? Are there certain forms that they can use to exercise their rights? I would guess that it would include just kind of asserting their standing. Should they write a letter to the judge?
No. So the challenge here is that judges have some limitations when it comes to ex parte communications, right? So what you don't want to do as a victim is write a letter to the judicial. You would have to write that to the judicial official and copy all the stakeholders. And that might not be information that you might be comfortable with all the stakeholders, and including potentially the criminal defendant and their lawyer seeing. So the judge has an obligation at that point to either ignore the letter or provide it to the parties. And the most prudent course of action is to provide it to all the parties. So you don't want to write that letter to the judge unless you're copying all the parties. Now, if you're in a situation where, say, the prosecutor is ignoring you and you're not able to make yourself heard, you could do it. I would just recommend you're going to have to send that letter for the judge to consider it. You're going to have to send that letter, both copy it to the prosecutor and the defense attorney. So that would be, I guess, the way you could do it, but you're a lot better off when it comes to, contact somebody like Megan about the best way to get a hold of the stakeholder that your interests may align with in the situation. I know she said she doesn't just talk to the prosecutor or the victim witness coordinator. There might be circumstances where she is consulting with the defendant's attorney, and it's usually best to go through that way, at least cleanest to go through that way.
There's also a form, I think that Ann mentioned the form earlier, CR 296, and that allows somebody to request enforcement of their rights. So that form is submitted to the court, and the person then fills out some information, including which rights they're requesting be enforced.
I would just note with that form that is also something that is in the court file. Everyone will see it. So I always, if someone's going to use it, I recommend that they be aware of that, because anything that they say in there, I always recommend avoiding talking about the crime itself, because that could be used later to impeach them. But unless they file an accompanying motion to try to seal it or something along those lines, that it will be part of the public record and everyone will get a copy of that. But yeah.
Great. If the judge is disciplined, is there a public record of that? Can
Yes.
people see? How much can they see?
If there's a public complaint filed and there's discipline, it's a Supreme Court decision just like any other. It is not confidential. It is accessible if you type in CCAP, if you type in the appellate version of CCAP, you type in Wisconsin Judicial Commission, you'll be able to see the cases that were publicly filed and the opinions by the court when there were opinions. There have been, not every case has always resulted in discipline, but the cases where there have been opinions by the court are at least the ones in the last 15 years or so. Those opinions are all available online.
Great. I just want to give the results from a poll we did through the app. The question was whether you could file a complaint with the Crime Victim Rights Board without going through OCVS's informal process first. The answers were pretty split, 50-50, yes and no. People thought you could or couldn't do that. I hope that maybe one of the main things we take away today is, as Ann and Julie have highlighted, you have to go through OCVS. You can't go directly to the Crime Victim Rights Board. So that hopefully is a point of education for the group today. Again, these are really confusing processes that people don't know about, so we're happy to provide that information. One final question we have is, and this is for anybody, and maybe these are kind of your wrap-up closing thoughts, what can someone do to avoid being the subject of a complaint besides their jobs and following the law?
I can bounce in for judicial officials. Be very careful if you get that letter from the victim, because we talked a little bit about how there's some dovetailing with the Chapter 950, but there's a real risk there that you're relying on extraneous information. And when you talk about fundamental fairness and proceedings before a court, notice and an opportunity to be heard for all parties is essential. But do that. If the Jessies of the world need to let you pass the case so they fill out the form, let them pass the case. If the prosecutor is giving you weird vibes when it comes to you asking if they've complied with victim rights notifications, maybe ask a few more questions. Even if the prosecutor that says the victim's rights have been complied with, ask out loud, is there anybody in the room that's the victim or anybody associated with the victim in the room? Double check, because the prosecutor may not even be aware that person slipped into the courtroom in the 5 minutes after they turned their back to handle the cases before them. And be patient. We know you have a big calendar. and you've got a lot of pressures on you as a judicial officials, but just realize that nobody else in this process really wants to be there. They didn't ask to be a victim of a crime. They're just trying to get through a really painful situation, and be patient and be empathetic. And those are the things I'd recommend for a judicial official.
Thank you. Ann, what about you? What about the DAs or the law enforcement, or, you get complaints about all these folks. So what would words of wisdom be?
Understand your role and what obligations you have as far as the provision of victims' rights and services. So review Chapter 950, look at the constitutional amendments. Julie talked about those reports and recommendations. Those are a really great resource for criminal justice professionals that have questions about the provision of victims' rights. I oftentimes review those in the work that I do. So really know what your role is, know what your responsibilities are to a victim, and allow a victim to be heard and have conversations with them so that they understand what their rights are. And that you make sure that you give them the opportunity to exercise their rights.
Thank you. Julie or Megan, any closing thoughts?
Yeah, I would say have policies and practices in place so that your standard operating procedure is protective of victim rights. Whether you're a chief of police or an elected district attorney, or, whoever you are, if you've got that power to put some policies into place and review your policies and make sure that everybody knows what's expected in your agency, because a lot of these things happen under pressure, right? Everybody's rushed, cases are backlogged, things get crazy. So if your SOP is you do these things as a matter of practice every day, it's less of a chance that when things are under pressure, things go wrong for a victim.
Thank you.
I would just recommend being transparent throughout the process, what your role is. I've had clients who think the prosecutor is their attorney and they're frustrated with their attorney, the prosecutor isn't doing what they want, or even just, hearing from law enforcement that, oh yeah, the DA is going to charge this out, you're going to get justice, to only find out that they didn't even refer it for charges. So really being transparent so that the victim understands what's going on, because at the end of the day, they just want to be included in this process, and to have them find out that, either you weren't being truthful or you were wrong or you were overselling it or underselling it later on, just be upfront with them. I think people really appreciate just being transparent and, not sugarcoating what the situation is.
Great. I think that's all really helpful. I know that you have provided a lot of information in the last couple hours. I encourage folks to look through some of the materials that have been uploaded in the app. The slides are included there, which has everybody's contact information and some of the links to some of the websites we've referenced. I see that Jeremiah has also put information in the chat with the link to some of the decisions from the Judicial Commission if you want to see the history of some of those. So with that, we are at noon. I have the privilege of saying goodbye to everyone for the day. Thank you for joining us this morning. We are going to start just in breakout sessions tomorrow morning at 8:30. So please join the track that you're interested in. Again, you can bounce between sessions as the morning goes on, but we hope to see you back here tomorrow at 8:30. Have a great rest of your day. Thank you to our panelists and our attendees. Bye, everybody.
Thank you.
This program is a production of Wisconsin Eye, an independent, nonpartisan, nonprofit media network with a mission to inform, educate, and engage the citizens of Wisconsin. Wisconsin Eye is the nation's first and only independently funded state civic broadcast network, providing gavel-to-gavel access to government proceedings and events at the state capitol.